Rommel Jacinto Dantes Silverio underwent psychological examination, hormone treatment, and breast augmentation in his attempt to transform himself to be a woman in Bangkok, Thailand. From then on, petitioner lived as a female and was in fact engaged to be married. He then sought to have his name and his birth certificate changed from Rommel Jacinto to Melly, and his sex from male to female. On the scheduled initial hearing, jurisdictional requirements were established. No opposition to the petition was made. During trial, petitioner testified for himself. He also presented Dr. Marcelino Recio Cruz Jr., a plastic and reconstruction surgeon in the Philippines, who issued a medical certificate attesting that Silverio had in fact undergone the procedure, and his American fiancé, Richard B. Edel, as witnesses.
Silverio filed the present petition not to evade any law or judgment or any infraction thereof, or for any unlawful motive, but solely for the purpose of making his birth records compatible with his present sex. Firstly, the court is of the opinion that granting the petition would be more in consonance with the principles of justice and equity. Petitioner's misfortune to be trapped in a man's body is not his own doing and should not be in any way taken against him. Likewise, the court believes that no harm, injury, or prejudice will be caused to anybody or the community in granting the petition, while granting the petition would bring the much awaited happiness on the part of the petitioner and her fiancé, and the realization of their dreams. Finally, no evidence was presented to show any cause or ground to deny the present petition, despite due notice and publication thereof. Even the state, through the OSG, has not seen fit to interpose any opposition. The trial court rendered a decision in favor of Silverio and ordering the Civil Registrar of Manila to change the entries appearing in the certificate of birth of petitioner, specifically for petitioner's first name from Rommel Jacinto to Melly, and petitioner's gender from male to female.
The Republic of the Philippines filed a petition for certiorari in the Court of Appeals alleged that there is no law allowing the change of entries in the birth certificate by reason of sex alteration. On February 23, 2006, the Court of Appeals rendered a decision in favor of the Republic. It ruled that the trial court's decision lacked legal basis and that there is no law allowing the change of either name or sex in the certificate of birth on the ground of sex reassignment through surgery. Thus, the Court of Appeals granted the Republic's petition, set aside the decision of the trial court, and ordered the dismissal of SP case number 02105207. Petitioner moved for reconsideration, but it was denied. Hence, this petition.
The arguments of the petitioner include the present petition not to evade any law or judgment or any infraction thereof, or for any unlawful motive, but solely for the purpose of making his birth records compatible with his present sex. Silverio also believes that after having acquired the physical features of a female, he became entitled to the civil registry changes being sought. He also claims that the change of his name and sex in his birth certificate is allowed under Articles 407, Acts, Events, and Judicial Decrees concerning the civil status of persons shall be recorded in the Civil Register, to Article 413, all other matters pertaining to the registration of civil status shall be governed by special laws of the Civil Code. Rules 103, change of name, and 108, cancellation or correction of entries in the Civil Registry of the Rules of Court, and Republic Act 1948, Section 4, grounds for change of first name or nickname. But Silverio's petition lacks rational basis on which the claim could succeed, therefore it is bound to fail. Arguments of the Republic include the names borne by individuals and entities are for purposes of identification, and a change of name is a privilege, not a right. Therefore, petitions for change of names are controlled by a law enacted by a legislature. Article 376, no person can change his name or surname without judicial authority. Article 407, acts, events, and judicial decrees concerning the civil status of persons shall be recorded in the civil register. Section 5 of Act 3753, registration and certification of births, and the Civil Code provision amended by Republic Act 1948 Clerical Error Law, in particular Section 1, authority to correct clerical or typographical error and change of first name or nickname.
Republic Act 9048 vests the power and authority to entertain petitions for change of first name to the city or municipal civil register or consul general concerned, but the intent and effect of the law is to exclude the change of the first name from the coverage of Rules 103 or change of name, and 108 or cancellation or correction of entries in the civil registry. Republic Act 9048 does not sanction a change of first name on the ground of sex reassignment, nor does a change of name not alter one's legal capacity or civil status. Rather than avoiding confusion, changing petitioner's first name for his declared purpose may only create grave complications in the civil registry and the public interest. Under Article 407, acts, events, and judicial decrees concerning the civil status of persons shall be recorded in the civil register. These acts, events, and judicial decrees produce legal consequences that touch upon the legal capacity, status, and nationality of a person. In contrast, sex reassignment is not among those acts or events mentioned in Article 407. Neither is it recognized nor even mentioned by any law, expressly or impliedly. Therefore, there is no reasonable interpretation of the provision to justify the conclusion that it covers the correction on the ground of sex reassignment.
Before a person can legally change his given name, he must present proper or reasonable cause or any compelling reason justifying such change. In addition, he must show that he will be prejudiced by the use of his true and official name. In this case, he failed to show. More importantly, it had no merit since the use of his true and official name does not prejudice him at all. For all these reasons, the Court of Appeals correctly dismissed Silverio's petition insofar as the change of his first name was concerned.
Under RA 9048, a correction in the civil registry involving the change of sex is not a mere clerical or typographical error. It is a substantial change for which the applicable procedure is Rule 108 of the Rules of Court.
To correct simply means to make or set aright, while to change means to replace something with something else of the same kind or with something that serves as a substitute. So the birth certificate of the petitioner contained no error. All entries therein, including those corresponding to his first name and sex, were all correct. Therefore, no correction was necessary.
Since there is no such special law in the Philippines governing sex reassignment and its effects, this is fatal to Silverio's cause. In such declaration, the physician or midwife in attendance at the birth shall certify to the following facts: date and hour of birth, sex and nationality of infant, names, citizenship, and religion of parents, or in case the father is not known, of the mother alone, civil status of parents, place where the infant was born, and such other data as may be required in the regulations to be issued. Under the Civil Register Law, a birth certificate is a historical record of the facts as they existed at the time of birth. Thus, the sex of a person is determined at birth, visually done by the birth attendant by examining the genitals of the infant. Considering that there is no law legally recognizing sex reassignment, the determination of a person's sex made at the time of his or her birth, if not attended by error, is immutable. For these reasons, while Silverio may have succeeded in altering his body and appearance through the intervention of modern surgery, no law authorizes the change of entry as to sex in the civil registry for the reason. Thus, there is no legal basis for his petition for the correction or change of the entries in his birth certificate.
The trial court believed that its grant of the petition was in consonance with the principles of justice and equity. It believed that allowing the petition would cause no harm, injury, or prejudice to anyone. The changes sought by Silverio will have serious and wide-ranging legal and public policy consequences. First, the petition was Silverio's first step towards his eventual marriage to his male fiancée. However, marriage, one of the most sacred social institutions, is a special contract of permanent union between a man and a woman. To grant the changes sought by petitioner will substantially reconfigure and greatly alter the laws on marriage and family relations. Second, various laws which apply particularly to women, such as the provisions of the Labor Code on employment of women, certain felonies under the revised Penal Code, and the presumption of survivorship in case of calamities under Rule 131 of the Rules of Court, among others. These laws underscore the public policy in relation to women, which could be substantially affected if petitioner's petition were to be granted.
Petitioner pleads that the unfortunates are also entitled to a life of happiness, contentment, and realization of their dreams. The court recognizes that there are people whose preferences and orientation do not fit neatly into the commonly recognized parameters of social convention, and that, at least for them, life is indeed an ordeal. However, the remedies that Silverio seeks involves questions of public policy to be addressed solely by the legislator, not by the courts. Wherefore, the petition is hereby denied.